Okay, if people want to grab their last of the sandwiches or seconds, please do. And our tradition is keep eating during and through all the discussions and talks as well. So even though this has a name to this lecture, and we take great pride in that, it's not meant to be any more formal than all of our amazing opportunities to hear from wonderful visiting scholars and enjoy some time together at the same time. And as usual, I know we'll both have the enlightenment portion where we hear about Isabel's current work, and I'm hoping some interactive portion as well where we can put some hard and interesting questions to her. Before introducing Isabel Karpin, who's here from Sydney in Australia, I wanted to just, again, because this is our Janae Memorial Lecture Series, just say a word again about how that came about. And by saying it, it always reminds me of what a remarkable legacy the friends and supporters of Pierre Janae created in wanting this kind of living tribute to him. He was an Osgoode graduate from the class, I think it was of 1954, a very well-respected litigator, advisor, known not only for his prowess as an advocate, but also for his grace as a person and the strength of his leadership in the legal community. And so for that reason, when he passed and his family and friends were coming together to look at what to create, the idea came together of this series, one that could bring together not just great lectures, but also visitors who would play a more active role in the faculty, who might teach an intensive class or be a mentor to graduate students, get involved in a clinical program, but something that would have a multicultural, cosmopolitan, outward-looking perspective for the law school, which very much embodied Pierre Janae's own broad and wide-ranging interests and outlooks. So we're glad to have the fund, glad to have invested it in some wonderful visitors this term, and of course glad to have Isabel here with us. She is known to many both personally and through her work. I won't do justice to her biography because I want to get to the main event, but some highlights include both her current post at the University of Technology's Faculty of Law in Sydney, and her previous stint at Sydney's Law School, which I'm trying to look at the date when you moved, so 2009 that the transition happened. And Isabel is also known for bringing together different disciplinary perspectives. You'll hear about this, of course, in her interest on biotechnology, the genome, reproductive rights, feminism, work that has crossed into social sciences, law, hard sciences, and back again. She has also come to us with graduate degrees from Harvard and Columbia, where we met some years ago. We don't have to say how many. And her interests, in fact, have consistently explored this intersection of ideas and practice in these fields, and most recently coming together in her Perfecting Pregnancy project, which is taken forms both in shorter works in book form and is part and parcel of a multi-year research project, and I hope we'll hear a bit about where that research is taking you. And there's a number of publications, some involving collaborations with Roxanne McKittick on our faculty and others who will be well known. The full list is available on the Janae link, and I encourage you to both read up on her work and read her work. And more importantly, I urge you to join me in welcoming Isabel here at Osgoode, and we very much look forward to hearing from you.
Hi, thank you, Lorne. Okay, do I need to move this, or is that, it's kind of in my face? Okay, Well, first of all, I'd just like to thank the Pierre Genet Memorial Fund and Osgoode Law School for inviting me to join what is an extraordinary list of visitors you've had under that Genet Global Faculty Program. I'm very honoured, and I'm also really looking forward to the opportunity to participate in some of the classes and seminars that I'm scheduled to do during my visit here. So that's going to be a lot of fun. So what I thought I would do as Lorne guest is present some of my recent research work, which steps off from the two major projects that I have just concluded and that have prompted some new questions for me in the field that I work in. So just to give you the background, the first project that I've just finished examined the legal function of the concept of serious disability and resulted in the book that Lorne mentioned called Perfecting Pregnancy. And it's a book I co-authored with my colleague who's actually at Sydney University, Kristen Saville. And really, it aims to rethink the way in which concepts of disability, normality, risk and seriousness are used in the legal regulation of prenatal testing, abortion and pre-implantation genetic diagnosis and selection. Pre-implantation genetic diagnosis, for those of you who don't know, is where they take a biopsy of an embryo before it's implanted in a woman's uterus to check for genetic conditions. And typically if it has a particular genetic condition that's being explored, it's selected against. In other words, it's not transferred. My co-author and I took an historical approach and we examined the evolution of legislative oversight of these technologies across a number of jurisdictions, including Canada. We also looked at the UK and, of course, Australia, which, if you hadn't already figured it out, that's where I'm from. And a major conclusion of the project was that there was a productive ambivalence around the idea of seriousness and disability that allowed patients and clinicians and regulators to approach people's complex decision-making flexibly. But at the end of the project, there was still an important question that remained unanswered and that I was attempting to address. And this is just the first incarnation of it. I'm going to develop it as I go through. Yes?
I need to use the microphone. It's just that way.
Okay.
I'm just going to move this out of the way. I'm sorry to disturb you.
No, that's good. That's much better. Now I don't feel like I've got this thing in my face. That's great. So basically, and this is a very kind of vague question I've put up here, and there's a reason for that. So at the end of that project, this was still this question that was bugging me. Accepting that there is no normative consensus about what constitutes a serious disability, do we nevertheless, as potential parents, clinicians, regulators, owe a duty to future children in relation to something we understand to be pressing, so this idea of this risk of disability, but for various reasons remains indeterminate? In other words, we can't really ever say what it is that we're actually worried about in terms of the drawing sharp lines around the boundaries of what constitutes a serious disability, which is the work that I undertook on the book just made that very plain. Nobody could come up with any kind of clear consensus about what they viewed was serious and what they didn't consider serious in terms of disability. And in fact, even what was a disability, let alone a serious one, was contentious. So this question, and I'm sorry it's written in this kind of, this is like you're getting to see inside my brain here, but it gets better. So the question coalesced with some issues that were unearthed during work I conducted on a second project called Enhancing Reproductive Opportunities, which interrogated how laws and policies in Australia, in the various states and territories, affected people's decisions about their stored embryos created through IVF. Now the research looked at 400 past and present IVF patients, and we interviewed a bunch of them and we did surveys with a bunch of them, and it was all over Australia. And although that project wasn't about disability, we actually came up with a rather unexpected finding, and that was that some clinics were actually limiting access to donor sperm and embryos where there was a potential genetic or inheritable disability. So 2 of our interviewees, which we called Scarlett and Laurie, that's not their real names, were denied the ability to donate their embryos because they had genetically affected embryos. And this was even though the recipients had been informed of the issue and still wanted to receive those embryos. And this was concerning, as the identification of genetic disorders remains imprecise, and moreover, in many cases involves wide variation in both the chance of transmission and the degree of presentation or actual experience of impairment as a result of the condition. Scarlett and her 2 children both had a genetic condition with a 100% transmission rate, but the condition involved possibilities of presentation that varied from very mild to more serious. Neither she nor, Laurie had a genetic condition with a moderate likelihood of transmission and a low impact of presentation. And neither she nor her daughter had actually been affected. So we interviewed Scarlett and Laurie some years after they had been denied their ability to donate their embryos, and both of them remained very upset and angry. And Scarlett, in particular, was interesting because she had actually insisted that her issue be put before the ethics committee of her clinic. Because she'd actually, when she'd been denied the right to donate her embryo anonymously, she'd actually gone out and recruited people who were wanting her embryo, aware of the potential for genetic transmission. And she was still refused the services to allow that donation to take place. So then she forced it to go to their ethics committee, and the ethics committee refused to transfer the embryos on the basis that this was not in the best interest of a resulting child. And this is the idea that I'm most examining in the course of this paper, as you'll see. So this is just a quote from Scarlett. She said in our interview, "I find it a really difficult argument to accept because I have produced 2 children from exactly the same set of embryos, and in essence they're saying that that was not in the best interests of my children. Now that's quite a confronting statement because I think my children are immensely loved and showered with everything they need, and they're well built up, well cared for, and it's hard to say that it was not in their best interests to even exist. I understand that from a legal position, the clinic has to choose the child's interests over the donors or the recipient, but I think they've interpreted it too harshly." So from this, we discovered that some Australian clinics, at least, feel legally obliged to refuse to allow the donation of embryos and gametes that may carry an inheritable condition based on their understanding of an overarching principle contained in our ART regulation that makes the welfare or well-being of the future child paramount. So my initial question, the one that was all messy, crystallised a bit in light of this second discovery and developed to this one here. So my new question is, do we, and this question arises, as I said, because there seems to be existing legal and clinical consensus that at a minimum there should be concern about the welfare of future children and their future well-being. Do we, as potential parents, clinicians and regulators, owe a duty to future children to ensure their future well-being is not compromised before they are born or even conceived? Now, before I turn to this in detail, it's worth pointing out that this overarching principle of the paramount welfare of the future child appears in a number of other jurisdictions too, including your own Canadian legislation and the Human Fertilisation and Embryology Act in the UK. And as I'll go on to show, it seems reasonably clear that both in Australia and the UK at least, this principle could potentially operate as a barrier to treatment for those prospective parents who might pass on a disability or who are at increased risk of passing on an inheritable disorder. However, the fact that a disability is or might be, the fact is that disability is or might be a status that is not inherently bad. And this raises the question, what do we mean when we legislate to protect the health, welfare or well-being of imagined future children? This welfare or well-being principle frames obligations to prospective children, and yet prospective children are a very peculiar category that embody, as Anna Muddy puts it, both the concrete and the abstract. In the context of ART, the protection of the welfare and interests of these imagined future children may ironically extend to the prevention of their conception in the first place. In other words, the entity to be protected may not ever come to exist in its own putative interests. In order to understand our obligation to regulate the future then, or to regulate the future well then, as my title implies, we seem to have set ourselves a double responsibility, not just to regulate the future well in terms of responsible custody of the present extending into the future, but also to regulate to ensure future well people. And here we're left to ponder what constitutes wellness, and does it presumptively exclude disability? Now, attributing interest to imagined future persons raises important legal and ethical questions. Their development and birth is highly contingent, and as future persons, they have no legal rights until they are born alive. It's nevertheless clear that decisions made today will have an impact on the projected health and well-being of future people. So in the remainder of this paper, I want to interrogate this idea of future well-being and future welfare and consider how we might frame a legal obligation to protect future well-being that does not presumptively exclude the future of individuals with disabilities. Now, I want to say that this is not irrelevant in the Canadian context, and I realise that there's a different context in which your Assisted Human Reproduction Act is working. But the principle is there in your Act as well. And so it's worth giving some thought to what are the implications of that principle. So here in Canada, the idea of well-being appears in the Canadian Assisted Human Reproduction Act. And also I'm aware that lots of parts of that Act have been made ultra vires by the Supreme Court, but not this one. It still maintains in Section 2 principles. And the first of those principles is this one, that the health and well-being of children born through the application of assisted human reproductive technologies must be given priority in all decisions respecting their use. So, and the there refers to the reproductive technologies. So these principles are offered as an aid to the interpretation of the Act when there's an ambiguity. And it seems clear that an overarching consideration when using this ART Act, when using ART itself in Canada, must therefore be the health and well-being of the child that might be born. However, there's no guidance regarding either the meaning of health or well-being. And Principle C requires that the health and well-being of women too must be protected in the application of these technologies. So it's difficult to be certain how these different principles would be balanced against each other when an ambiguity arose. And for instance, Principle E too, which requires non-discrimination, might operate to give content to what constitutes well-being under A and C. So I just leave that Canadian question to one side for the moment because in both the UK and Australia, these principles are taken have been more proactively applied. So I suppose it's really a question of whether that would ever happen here. So in the United Kingdom, Section 13(5) of the Human Fertilisation and Embryology Act specifically precludes treatment unless account has been taken of the welfare of any child who may be born as a result of the treatment, including the need of that child for supportive parenting or of any other child who may be affected by the birth. Now, unlike its Canadian counterpart, this section of the HFEA Act has been the subject of significant scrutiny and was amended in 2008 to remove the phrase. So previously that phrase, including the need of the child for supportive parenting, was including the need of the child for a father. And that was removed in 2008 and replaced with this more non-specific supportive parenting. And because it's been through that reform process, there's been a great deal of scholarly discussion about what it means anyway, and a lot of criticism of this provision in the first place by feminists in the UK. Now, as you can see, I have up there also that supportive parenting is described in the Code of Practice as a commitment to the health and well-being and development of the child. It is presumed that all prospective parents will be supportive parents in the absence of any reasonable cause for concern that any child who may be born or any other child may be at risk of significant harm or neglect. And so there is a presumption in favour of the parent in this instance, that they will probably be good. However, the concepts of health and well-being are not defined, neither is welfare. Although they haven't been defined, the HFEA authority, the A is for authority, has developed a form which assists clinics to determine whether there is a welfare of the child issue. And that form is used by most clinics when they're deciding whether to allow a couple to access IVF services or a single woman to access IVF services. So everybody has to fill out this form. And the form asks people about all of these things: previous convictions, child protection measures, serious violence, discord in the family. I'm pretty sure we all have that at some point. Mental or physical conditions, and the one that I'm particularly interested in, risk of transmissible or inheritable disorders. So this is the form of the question. To your knowledge, is your child at increased risk of any transmissible or inheritable disorders? Because, of course, that implies that where such a risk exists, this may raise a welfare of the future child issue of concern, and therefore might trigger the requirement that the clinic refuse services. Now, recently, the University of Kent researchers Ellie Lee, Jane McVarish and Sally Sheldon undertook a study of UK clinics, exploring the kind of welfare assessments procedures in place and trying to determine how often there is a refusal to treat. They concluded that it's very rare that there's a refusal to treat. But most of the clinics did indicate that they used this form, and all the 20 clinics that they interviewed indicated that they had investigated cases further following a risk assessment that identified a transmissible or inheritable illness. Now, although they don't discuss the specifics of that finding in their report or their follow-up article, I've had a bit of an email exchange with Jan McVarish, who dug into the interviews for me and found evidence that, in fact, it is a consideration. In one case involving cystic fibrosis, the clinician indicated that he would have allowed treatment on the assumption that the couple would use PGD or PND, presumably with the intention of screening out or terminating an affected embryo or fetus. But another clinician indicated that if a man tested positive for CF, you wouldn't use them as a sperm donor, and a similar approach would be taken to a woman carrier of CF who wanted to egg share. So there does seem to be this distinction between own use and donating it to others. Okay, so now just turning to my own country, there's been a few rather interesting cases. So in Australia, our National Health and Medical Research Council ethical guidelines on ART state similarly in Article 2.5 that the welfare of people who may be born as a result of the use of ART is paramount. And these guidelines apply across Australia and in Victoria, South Australia and Western Australia there are additional legal requirements that enhance this obligation. Unlike the UK, the legal scope of the welfare of the future child principle is not well defined. But there have been 2 Victorian cases where the principle has been directly relied upon. In one instance, it was used to initially deny access to assisted reproductive technology services, although that was overturned later on appeal. And in the other, it was used to deny access to PGD for sex selection. Both cases referred to the guiding principles in Section 5 of the Act, which are that the welfare, it mirrors the NHMRC, the welfare and interests of persons to be born as a result of treatment procedures are paramount. Now, I just want to go into a little bit of detail about those 2 cases because I think they're interesting for the way the court struggled with this idea of a future child and how you might characterise it as something to protect and in what what characteristics it has in order to require that kind of protection. So in the case involving denial of ART treatment, the principle was used by the court in adjudicating whether to overturn a decision under Section 14 of the same Act that creates a presumption against treatment. And that's interesting in that it compares with the UK, where there's a presumption of good parenting. Here in Victoria we have a presumption against treatment, where a person or their partner has a criminal record involving a violent or sexual offence, or who's had a child protection order issued against them. So everybody in Victoria who wants to get IVF has to go through has to have a criminal record check, which is pretty controversial. So in this particular case, a woman was denied treatment because her husband had been convicted of having unlawful sex with a girl of 16 while he was her teacher's aide. The Victorian Civil and Administrative Tribunal, however, found that she should not be allowed to access IVF because, in their view, that she should be allowed to access IVF because in their view, the welfare interests of the future child were not at risk from the husband. Now, they based their decision on evidence before the court provided by various experts that while he had broken the law and he had been convicted and he'd paid his penance, gone to jail and all that sort of stuff, he was not a threat to his future child. So the patient review panel that had originally denied access to the woman appealed to the Supreme Court of Victoria. And the Supreme Court of Victoria then went into a little bit more detail about what they understood by this idea of the welfare of the future child. So commenting on the difference between assessing the best interests of an existing child and one that has not yet even been conceived, the court rejected the view that a reasonable determination could be made as to whether a child's quality and condition of life and well-being was better than the child not existing. So they really weren't very helpful at all. They just said, we can't make that conclusion at all. And then they went on to also reject the view that what was required was the best possible parenting. So you don't have to be a great parent. And instead they settled on the interpretation that this welfare of the child principle would include a standard that looked at the physical, sexual, emotional and developmental well-being of a child. So you can see that's a fairly vague statement and not particularly helpful for the kinds of determinations that we might want to go on and make. And it doesn't provide any direct guidance on how a court would define welfare in relation to a transmissible genetic condition. But of course, that's because the focus of this case was on parental behaviour. However, as I noted before, it certainly is the view that some clinicians that transmission of an inheritable genetic condition would be a welfare of the future child consideration. And the second case that I mentioned involving the denial of a request by a couple for to use PGD to select the sex of their child is an example, provides a bit of a sideways example of how that might be the case. So basically they had argued that they should be allowed to use sex selection under this Part B here, the bottom one, which is really, you can't sex select unless there's you're selecting for against a particular disease or disability in a particular sex, unless the patient review panel says you can. And so they were going for this one, to have the patient review panel say they could. And the reason that they were arguing that they were in a special category was that they had suffered a dreadful pregnancy loss. So they had 3 children of one sex. And the woman lost her 4th child in labour, probably due to medical negligence. And the 4th child was of the other sex. So she lost her opportunity to have a child of the other sex. And they've been dreadfully traumatised by the loss of that child. And they argued that they suffered from post-traumatic stress disorder. And they felt that being allowed to have a child of the same sex as the child they had lost would go some way to allowing them to move on with their lives. And they were so committed to the process that, having been denied the right to sex select in the first instance using PGD, they'd gone ahead and become pregnant 4 more times. The first time they had a child, but the child was not the right sex or the desired sex. The second time resulted in a spontaneous miscarriage. And the third time, which was a twin pregnancy, they'd had to terminate because there was only one placenta. The fourth time, which was probably the most controversial, was when they used IVF to actually get pregnant with twins, discovered they were not the desired sex and terminated. At the hearing, the couple said they would continue in this way if they did not obtain approval for PGD for sex selection. In denying that request, the Victorian Civil and Administrative Tribunal stated, "We do not consider it is in the interests and welfare of the child to be born that permission should be given to permit the use of an embryo which has been sex selected for the purpose of producing or attempting to produce a child of the desired sex." And they went on to say, sorry, it's a bit squashed at the bottom there, but in our view, arguments based on completion of family, replacement of a child, or family balance do not advance the welfare interests of a child born to fulfil that end. As Professor Thompson and Associate Professor Tonti Filippini said, it is ethically undesirable and contrary to the welfare of the child to make acceptance of a child conditional on its sex. I mean, the problem with this is, of course, the child being talked about doesn't exist. And so you get this sense of a kind of concrete entity at the same time as the whole purpose of the decision is to preclude its existence. And so I think that really needs to be somehow unpacked. But that's another kind of conversation. What I'm interested in is the way this is in stark contrast to the practice of allowing sex selection for medical reasons. Because there seems to be almost universal acceptance of the use of PGD for sex selection to avoid transmission of a sex-linked disability. In Victoria, which is where this is all happening, as in the rest of Australia, Canada and the UK, sex selection is specifically allowed in legislation where it is for so-called medical reasons. I'm not going to spend a long time, but I just put this up for your information. So it's in Section 5 of your Act again. Of course, another provision that is still okay. So you see down the bottom, except to prevent, diagnose or treat a sex-linked disorder. And in the UK too, we have, you can't have sex selection except if it's a gender-related serious physical or mental disability, or a gender-related serious illness, or a gender-related serious medical condition. I don't know why they use gender rather than sex, but that's something I'm exploring because it's a really interesting shift. Since gender is typically understood as a kind of cultural phenomenon, whereas sex is biological. So I'm going to go and look at the debates and find out why that language was there. Although I spoke to Emily Jackson, who was the deputy head of the HFEA, and she said she imagined it was just nobody thought about it. Basically, what I'm trying to get to is this. There's a great deal more that needs to be said about the question of what disabilities or genetic conditions or diseases are compatible with well-being or welfare in the view of the law and clinicians and the rest of us. However, given that I have limited time and I've probably already tried your patience enough, what I wanted to do today was just focus on one category of disability and proceed by way of a case study. And the case study I'm referring to is the use of PGD to deselect boys in family where there is a history of autism. So in Australia, the use of PGD for this purpose has been approved in most jurisdictions. In fact, it was approved in Western Australia at the end of last year, but it's been approved in Victoria for quite a few years. In Western Australia, the RTC, that's the Reproductive Technology Council, approves the use on a case-by-case basis, and in its most recent instance, the couple in question already had 2 sons with autism. And the statistic that they rely on is this one that's very well circulated in the literature, and the basis of that decision, and that is that boys are at least 4 times more likely to develop autism. Now, as I'm going to go on to show, this statistic has recently been questioned, and so its use as the basis for these kinds of decisions is contentious, to say the least. But choosing the sex of one's child for purposes not related to the prevention of disease is typically considered a frivolous and potentially sexist use of expensive technology. But choosing the sex of your child to avoid a potential disability, as I've said, generally considered appropriate where the disability is viewed as serious. But what if the disability, disease or condition that is sought to be prevented by sex-selective procedures is itself embedded in gender stereotypes? And this is precisely the situation with autism. David Armour, a geneticist at Melbourne IVF, has described autism as an example of a condition which is substantially more common in one sex than another, but is not caused by a single gene and does not follow Mendelian inheritance. He considers it to be a condition that is caused by multiple genetic influences, where the contributing genes are either unknown or poorly understood, where specific gene testing is not available, and where environmental influences may be important. Now, I don't have time to go into this debate that's currently raging in the scientific community about geneticisation versus environmental causes of autism, and also neuropathology. But by way of an aside, there's just no consensus on the cause of or limits of autism. And yet we have this genetic testing procedure. So Armour argues that for a couple with one autistic child, gender selection in favour of female embryos would reduce their risk of having an affected child from 5% to 2%. This means a risk reduction of 3% against the increased risk of using IVF and PGD, which amounts to about 1%. So in about 1% of cases, there are effects from the use of the procedure that might be damaging to the child that's born. Or to put it another way, for a family where one child is affected by autism, it is the choice between selecting a female child who has a 2% chance of being affected rather than a male child who has an 8% chance of being affected. Now, I know these numbers are small, but still you can see why the argument becomes kind of compelling, right? Now, putting aside for the moment the fact that the clinical range in autism is broad, ranging from relatively minor difficulties with communication and socialisation to individuals with severe intellectual impairments who are unable to communicate. In the case of autism, another interesting dimension must be considered, and that is the gendered construction of the condition and its diagnosis. Now, if you look at this table, I don't know if you can actually read it from where you are, but you'll see that the list of conditions that Armour put together of non-Mendelian disorders where there's unequal sex incident, apart from perhaps intellectual disability, these conditions all differ from autism in that they are not diagnosed solely using behavioural symptoms. There is as yet no biological marker or diagnostic test for autism. Currently, the gold standard research-based measure used in assessment of autism are the Autism Diagnostic Interview and the Autism Diagnostic Observation Schedule. There are other tests used, the CAST test and the Dorber test, but the point is that most of these involve parent interviews and observed behaviours. While there are some instances where autism is associated with conditions that do have a biological marker, such as Fragile X and tuberous sclerosis, what's interesting about the fact that autism is diagnosed in this way is that recent studies have shown that the testing itself may contain gender bias. So according to studies published in Social Psychiatry and Psychiatric Epidemiology, doctors are more likely to miss autism in girls even when their symptoms are as severe as those as boys. And the general belief that girls don't get autism may be such a powerful bias that it operates even when girls are severely affected. Furthermore, in a study by Constantino, it was found that it requires a relative increase in the total symptom burden in a female to cross the threshold of diagnosis of autism compared with a boy. She noted that even with comparably high levels of autism spectrum disorder traits, girls are substantially less likely to be diagnosed than boys, unless their conditions are compounded by cognitive and other behavioural deficits. So her conclusion is that this reveals a significant problem in the current diagnostic approaches, or indicates that in the absence of accompanying cognitive or behavioural deficits, girls in fact exhibit better adaptation to the same levels of diagnosis in boys. This study and a spate of other recent studies suggest that with available diagnostic tests, higher functioning girls with autism are being diagnosed either later than boys or are altogether missed. And she suggests that we should be developing gender-specific thresholds, which is another very interesting question then if you're going to gender select particularly. But the problem goes somewhat deeper, I think. Simon Baron-Cohen has a theory, for example, that autism is a form of extreme male brain. And it's based on his view that autistic people are hyper-systematizers. On average, he argues that male brains are more systematizing, while the female brain has a higher capacity for empathizing. Now, Baron-Cohen is extremely well regarded in the field. He's won various prizes, he's at Cambridge, so this is not just some, crank, right? And of course, he's come under criticism for this theory. And there are a number of feminist responses that challenge both the premise that autistic people are on the whole hyper-systematizers, and that this can be characterised as a masculine brain trait, or indeed that there are only two types of brains. Baron-Cohen, for instance, associates this systematising brain with engineering, mathematical and science skills, and has argued that when, quote, geeks are attracted to each other, that they tend to produce autistic kids. Oh, no. Yeah. Now he's been criticised for this, and he's agreed that his data isn't very strong. Basically, there's been a in so-called places that are like Silicon Valley all over the world, like the Netherlands, he's just looked at the data and seen that there's more autistic kids in those communities than there are in other communities. But he hasn't looked at whether their parents actually work in IT. So there's a lot of gaps. He's been criticised for the weakness of his data and the assumptions that he makes. And for instance, the fact that there are more male mathematicians doesn't mean that men are naturally more systematic. This is all old stuff. Social, cultural, environmental factors must come into play here. We all know that, right? But even if we were to accept that there's a difference between men's and women's brains, what's particularly interesting is that Baron-Cohen has not identified a pathology associated with the extreme female brain. And in fact has suggested that a tendency to hyper-empathise would not involve a pathology. And this may be to do with the fact that a small component of the group that are classified as autistic have very high functioning abilities, and sometimes described as savants or usually categorised as Asperger's. And those, Nancy Bombachi has argued that this alignment between Asperger's or savantism and genius also aligns with the construction of genius as gendered male. So thus extreme femaleness or hyper-empathy may not be valued, or let's say it might not be noticed to quite the same extent as hyper-systematizing. Now, while I can't possibly hope to settle this debate here, I just want to offer it as a way of demonstrating the limits and ambiguities inherent in distinctions that are being made between medical and non-medical justifications for using selection technologies, and just exactly how we constitute ideas of welfare and well-being and wellness. Clearly, the idea of well-being or welfare is highly contentious, and even more so when it's a projected state attributed to children that are not yet born. And the example of autism shows how important it is to be aware of the cultural framing of disability and the gendered notions of harm. So if I return finally to my original question, do we have an obligation to future children to ensure their future well-being is not compromised before they are born? The answer seems to be that first we need to open up a space for negotiating the meaning of well-being and the broader cultural conceptions of certain disorders. Now, if disability were a biological condition that was just inherently bad, then it would be possible to argue for the eradication of disability where this is possible. However, we have just seen that not only is it not always bad, it's also often associated with particular norms and cultural limits that cannot be simply diagnosed as pathology. Now, from my perspective, as an Australian, this is really worrying because it's predicted, well, I'm predicting, that existing regulatory limits in Australia on who may access ART based on the projected welfare of the future child will be placed under greater pressure to exclude parents likely to pass on a heritable condition. And this is reinforced by the existing clinical practices that we've unearthed in our study, where clinics have refused to allow the donation of gametes or embryos that have a chance of passing on a heritable condition, even where the people involved want it. However, clinicians who offer the use of in vitro fertilisation combined with pre-implantation genetic diagnosis to avoid having a child with a particular genetic condition, disease or disability, and do so with this overarching principle in mind, that they're operating in the best interests of the future child, even when it means preventing its birth, are faced with a real dilemma when the evidence of what is a harm that would impinge on the future well-being and welfare of the putative child, and you see how I have to qualify everything, is murky at best. That's all.